in studio right now is Bill and Virginia Jaquish. Guys, good morning.
Morning.
And the battle continues at the Creekside Mobile Home Park. Now, last we spoke, the Supreme Court had ruled, we're talking Herkimer County Supreme Court had ruled against you, and you guys were going to possibly appeal. Where are you now? And I know I just received a contempt of court motion that's been filed against you, and you guys will be going to court next week on that. So where do we stand now? Where are you guys?
Well, right now we have applied to the appellate, and the appellate is going to accept their case. We're just having a problem with the town agreeing. They keep doing one thing after another to try to get our case dismissed.
Okay.
So it would have been already, but we've had to file for extensions and so forth. But it is definitely going to the appellate. And it's kind of foolish to say that people have to all be out of the park and the park dismantled before we have the chance to be heard.
Right. You've not gone through you haven't gone through the whole process as of yet.
No. Not
so
at all.
when do you plan to have? Do you have any idea when that court appearance is going to be in the appellate?
No, because we're waiting from the appellate for the word on that, because there's a lot of briefs and things like that. There's a lot to it.
But it has been filed with the appellate court then.
Well, we filed our application for it. Now we have to get all the information in and so forth. But as far as you read earlier about these buyouts and whatever, we were offered a buyout after the flood to begin with, and it was just $66,000 for our whole business and everything else. That was it.
That was right after 2013 into 2014.
Okay.
And as far as the second buyout,
I want to read the. I want to read the. Let me read the statement if I could here. And Andrew, just help make sure they're right up on the microphone. This comes from Frank Spotto, who is the town supervisor, and I'll read the whole thing here if I can get it all in. They're saying that the town has a legal mandate from the Federal Emergency Management, FEMA, to enforce its floodplain development law. Not only does the law protect lives and property, but maintaining a good standing with FEMA's program allows residents and businesses in flood-prone areas to obtain mortgages. It's bigger than just this particular case, Spotto said. In an effort to resolve the case and save legal fees to both parties, the Jaquishes were twice given the opportunity to participate in a buyout program. Like many others in the community, they could have sold their property at fair market value as determined by independent appraisals. They refused to participate and instead have focused on prolonging the litigation. So you're saying you weren't offered two buyouts?
No. The second one, they said they wanted to negotiate, and they kept making appointments for our lawyer and their lawyer to come and negotiate. And they kept canceling them. And then our briefs were due on, I forget if it was July 23rd, something like that. So they had a Supreme Court with the judge on this buyout. We were never given any offer of money, or they didn't do the appraisals. There was nothing. And then that day he said, forget it, everything's off anyway. It was kind of a stall tactic, so we would miss our time.
Who said that? Everything's off, forget it.
Michael Moore, the town's attorney.
Okay.
Now, if there is, and if to make this statement and to say that there was a second offer and then we refused it, please bring that offer, whatever it is, on paper, bring it out and show the taxpayers, and please, provide a copy to our attorney and us, because there is not one.
All right.
And so I'm saying, if it's there, bring it, show the taxpayers what the offer was.
Well, they're saying we're prolonging this case and it's costing taxpayers money and whatever. Absolutely not. They're the ones that are dragging it out. We've tried to get this in.
And secondly, when you start talking about that they're going to, that FEMA mandates this, here's just a couple quick little headlines. They're using preliminary data. Preliminary data are not for use, distribution, or replication until the data are finalized and labeled effective. Unlike preliminary data, effective data and maps are official and should be used for national flood insurance programs. This is FEMA. You can go on to FEMA's website.
Yeah.
We didn't write this. And the town is bringing this action against us, all based on preliminary. Frank's making that statement that they're going to lose this. It's not the case. So there's always two sides to a story.
We have not been cited by FEMA, by DEC, and they're saying that we violated with DEC. We've not been cited by either one of them in any way, shape, or form. We comply. When we put this park back together, every single thing complies to every standard. They refuse to come in and
FEMA set the standards,
inspect.
which we followed.
Yeah.
Period.
They're saying, of course, initially, according to Frank Spotto, he says the Jaquishes have ignored the court order and have kept the park open, threatening public safety and exposing park residents and those downstream in the village of Mohawk to harm from another flooding event along Fulmer Creek. With this recent weather pattern as an example, it's just a matter of time. Do you want to comment to that?
Yeah, I do. How can he predict that this is going to happen here, anywhere? How can you say that? I mean, this thing it all complies. It could happen anywhere. We've seen it everywhere and anywhere. This park is not jeopardizing anyone downstream it never did. Even with the one flood that we had, nothing caused harm to anyone else.
We've experienced major, rainfalls here. A week and a half ago there,
I was going to ask.
We monitor that. We had over 5 5/8 inches of rain in a day and a half. Okay, we monitor this very well because, being a concern, the creek came up a possibility of 2 feet. Okay, and pretty much what, I believe that this really is proved to the residents. We had flooding all the way around us.
Yeah.
Herkimer got hit again, lower part of Mohawk got hit again on a little tributary that comes down there. But the maintenance that we had in the creek, when the creek got cleaned after the 13 flood, it shows that we need maintenance. And this is something that needs to be followed through.
And you didn't have any flooding issues?
Not an issue at all. An issue at all.
Yeah, that was one of the questions I had. Jeff Reinhardt is the town's attorney, one of the town's attorney. He says the town did not choose this course of action. It was the Jaquishes disregarded the laws that forced the town to take legal action to protect every other resident in the town. When a violator decides to ignore the law and then fight enforcement proceedings, the town can't just say, okay, never mind. The laws we're enforcing were established to protect public safety, ensure eligibility for federal flood relief, and for residents and businesses to remain eligible for flood insurance. We cannot sacrifice those things that are a benefit to all residents to favor a single property owner. Do you want to comment on that?
There's no sacrifice of this FEMA flood insurance. They're using that to convince the taxpayers. That's why they've spent $225,000 already to fight this case. They're the ones that have prolonged it. We're the ones that have applied to the appellate. We're going to the appellate. I'll be honest with you, they're saying this because people are upset that they've spent this kind of money. And
I do wonder why they would file contempt of court charges before the court proceedings have been completed. I mean, if you're still pending or attempting to take this to the appellate court, you have every right to appeal.
Yeah.
And so how could is a judge going to put you guys in jail or ticket you or something? Are they going to how can they do that without the appellate ruling on this? I don't understand that.
The appellate says that our case has merit. Okay, a couple of times they've already tried getting our case dismissed. The appellate says the case has merit, and they are going to hear it because they know there's another side to the story.
Yeah.
The thing of it is can you follow through? I mean, how do you follow through and say that that we are in contempt? Yes, the judge made an order, but also the judge in his order that he had given, he says, I'm also allowing the Jaquishes time to appeal this. So if you're allowing someone a time to appeal a case and take it to a higher court, then how can you enforce this? Why are you enforcing this action?
The judge is the one who makes the contempt of court charge, I guess, if I'm saying that correctly.
They filed the motion. A motion has been filed against Creekside Mobile Home Park owners, the Jaquishes, for contempt of court. So is this a way, though, for them to get comments out? I don't know.
I think
because this is the first time we've really gotten, both from the attorney and Frank Spotto, it's the first time we've gotten their side of the story. Up to this point, it hasn't been something that they've said they have been unable to talk about.
Well, I think they're trying to justify spending all the money, number one. Number two, if that park, he's trying to get rid of the park before we have the opportunity to go to the appellate, because what would be the purpose of going to the appellate at that point if all the people are gone?
Yeah, I don't think that can happen, right?
Well, that's what they're trying to do. That's why they filed this. Yes. I mean, we don't believe it can. I mean, the appellate will step in.
Your attorney is it still the same attorney? Who do you have now?
Audrey Dunning.
Okay, so this is an appellate, somebody who's well versed on the appellate court.
Yes, and
what is she saying to you?
Well, she's saying that we will follow through. She says hopefully before that, the appellate will step in and say they're going to the appellate. There's no reason they have to stay.
And you shouldn't even have to go to the hearing at that point, I would imagine.
We shouldn't, but...
Right.
The thing of it is typically until the town brings a motion against us, okay, or files an action against us with the Supreme Court to evict the residents, okay, until they bring that, can we get a stay? This is right from the appellate. If you get a stay, that means that everything stays as it is.
Right.
Until your case is heard.
Right.
So until they have brought an action against us, can we apply for the stay? Now that they've brought an action against us, we will be applying for the stay.
Okay.
So it's a whole process that you have to do.
All right. Okay.
But there's much more to this picture than why all this is coming out, I believe.
And I got to tell you, and people that I've spoken with, I have a lot of ties to German Flats and the Mohawk and Creek Road and all of that. But I've heard people that vehemently support you guys. But I've heard people on the other side that have said enough is enough. I mean, haven't you guys just gone on? I mean, you're just better off taking a deal and moving. What do you say to those people?
Well, there's a lot to say to that. Is number one is take a deal. What's the deal? The first offer was over around $180,000 for the park, okay? Our take was $66,000, all right? The rest of it was for asbestos abatement. Wait a minute. And cleanup of the park, okay? Removal of everything there.
Is there asbestos there?
No, there's no asbestos there, okay? But this is all what's on their sheet, on their rundown. Our take was $66,000. You could buy maybe a unit and a half for $66,000, okay?
We own all the units.
Oh, you own all the units.
All right. Now, secondly, that goes with this is income property, all right? What is the longevity of this? 10 years, 20 years, what will this park generate? So, number one is let me take your pension away. Let me take the town's pensions away, their hospitalization for the rest of their lives. This is what you're talking about. Mm-hmm. You're not talking about just closing a park and the safety of people.
Right.
They make the comment that the people downstream, the village of Mohawk, are in harm's way. Please bring forward from the village of Mohawk any paperwork or any documentation that they are concerned about this park causing them damage downtown.
This park has been there since 1963.
Yeah.
And, it's just taking away our income. We've worked hard for it. I don't know. Maybe we have 10 years, 20 years left. That's our income.
Right.
And we've worked hard. We borrowed money to build this back. And after we built it back, they're now taking us to court to get rid of it. It's obvious it's a personal thing.
How many units again? Do you live there as well?
7 units. No, we don't live
there.
there.
We live just up the road.
So 7. Okay.
Yeah.
And then the idea that you're affecting somebody downstream, you don't feed into the creek there. You don't do anything to the creek, do you?
No.
Oh, are they saying that one of the mobile homes could be washed into the creek and then,
Yes.
or debris could be washed into the creek and then come down and ultimately potentially hurt someone?
FEMA says, and the chief floodplain administrator, you can go to the websites and find this stuff. It says manufactured mobile homes can be in a floodway. I'm surprised at that word, okay, because the floodway is the creek itself, all right?
Okay.
So, the water itself. But it says that they can be there providing they meet certain criteria. This is from FEMA. This isn't from Bill Jaquish or a local engineer. But they have to meet criteria. They have to be established 2 feet above base flood elevations. Mm-hmm. They have to be properly anchored and everything else. We have followed all the FEMA guidelines.
Well, one more thing. We keep talking about these FEMA restrictions or guidelines or rulings or whatever. What could you have FEMA come in and say, take a look at this and certify this place? Or the state DEC or someone? Can you have a federal or state agency come in and say, yeah, they're fine?
Well, the town's codes officer is appointed the floodplain administrator. Okay, so of course on that level he has the right to come in and inspect. The town refuses to come in and inspect. In a statement, in an affidavit that was done, the codes officer admits that 5 out of the 7 units are clearly out of the floodplain area. Even he admitted that he could do a building permit for those units, but refuses to because there's 2 in question. Refuses to because of the litigation that's going on. So number one is, why is it ordered that you close an entire park when there's 2 units in question.
Possibly in question. That's all
Possibly
on preliminary.
in question.
They've
Based
been
on
there for.
preliminary mapping.
We have the.
So would you not fight for what you feel is right?
No, I listen. I understand. I totally understand what you're saying. I guess I'm just scratching my head. It's so two sides so opposed.
Well, and you also have something here where they're saying that you after the first flood, that you applied for permits and they denied you those permits, and you went forward and fixed the property anyway. Is that the case? Is that what you did?
Yes, correct. We did. We continued working on the property. I mean, we had a lot of, there's a lot of money there at stake, you know. So we continued. The big thing is it was all based on a preliminary map, and that's my standing today. Based on this manufactured home, these homes are in exactly the same footprint as they are. We have aerial photographs of that when it was all blacktop driveway, white lines, parking lines, and everything else. So it's on the same footprint as it is. There's nothing that's changed.
I want to stop just a minute. Those units are exactly where they were before, and it's the same units that they're talking about. And we just moved them aside. They were on engineered gravel pads. That's what washed out in the flooding time. So he does concrete work for a living. Moved them off, put a concrete pad in, put them back on, secured them all according to town standards, FEMA standards. And we have all of our permits with the Department of Health, the state, everything except the town.
So here's something that I have to ask you about, because I don't know if I'm right or wrong on this, but I've heard stories of a township. So you have to go to the town, you get your permit. Somebody goes and doesn't get a permit, and they build a structure. No matter how much money they put into that structure, I've heard stories of the township making them tear that structure down because they didn't have a permit. If you did work without a permit, can you win that in court?
We first started without a floodplain development permit. We didn't know about this because we didn't. I mean, we're not building a new development.
Right.
We were just putting back what was there, making it better, let's put it that way. And they just kept coming after us. So we did floodplain development permits. We've handed them in 3 times, and they just, every time we do, they tell us we have to do more. And they want all these expensive HECRIA studies and speedies. They tried everything possible to say that just to make us have to spend money, and it's impossible.
But is there a gotcha here? If you move forward and you did work on a property without the proper permit, do they have you on that technicality?
I don't know. We had turned in floodplain development permits and building permits. We had 2 engineers, do the design work for us. Frank Jennings was one engineer. Frank Jennings was actually the codes officer for the town of German Flats for more than 11 years. Frank had did the design work on the concrete slabs for us. We had turned them in with a typical basic building permit that I've always turned in for my 40 years of doing construction business wherever. They said that his work was too vague. Now, here's a codes officer that worked for a state engineer, retired state engineer. Ken Roberts also. Frank has since passed away. Ken Roberts is another professional state engineer, licensed engineer from New York State. Ken had come in the park and did design work for the park, overlooked the park, and we had turned that in. They said that Ken's work was too vague. It was nothing but just a ditto of Frank Jennings' work. But when you go and get the building permits, down the application for a building permit, on the back of that, they can't just list a particular engineer or whatever. There's multiple engineers on there. The engineer, one of the engineers that is on the back of that building permit that you can contact is Ken Roberts, LLC. So it's funny that they can use him. He's there, but all of a sudden his work was too vague.
And then they went out of town to get engineers to do this, who walked through the park for less than 5 minutes and then drew up all these things on the computer and everything and said we brought in fill. The only fill that's been brought in was what Frank Spotto brought in and back on his property, which is right in front of the park, and raised it like 3 feet. He brought that in when they did the school annex. They gave him the stuff. So our park, got more damage because the water was contained because of that.
All right.
We didn't bring in fill. I mean, you can see the existing concrete sidewalks and so forth that were all there.
And the other big issue that they have, too, is they talk about this park wall that we constructed, okay? The DEC had put in, I know we mentioned this before, but the DEC had put in like roughly 185 feet of wall, 2 rows high, the very large stacked stone, so approximately 4 foot high. originally we have foiled this. Originally they were supposed to do 300 feet, 3 rows high. Well, somehow this got shortened up. Well, after this, so this was in 06.
No, 07. We never
Yeah,
got
07,
it.
right.
Frank
They didn't do
got
it-
the wall across from us on that property that there were no buildings on in 06, right after the 06 flood. We didn't have flood, we had erosion in 06.
Yeah, okay, all right.
So anyways, they continue in, so after this, the 2013 flood, we still had the balance of roughly 115 feet of the park where there was considerable erosion downstream onto the banks and stuff. The DOT came in, Department of Transportation came in, the state, and they built the wall back up to the same level that we have, the 4 rows high, for the balance of the 115 feet. If there was a situation, wouldn't the state had come in to us and say, "Wait a minute, you guys aren't safe here. Why would they put a wall back up on our property? No cost to us."
Right, right.
And the thing of it is all the way from, you can go right from 2008 when we added to the top of that wall, and right up until 2000, and even to current, we have not been cited by the DEC. We have not been cited by FEMA or the state. And the town has issued all the operating permits through 2013 to operate that park. They have given us a building permit for that unit that is in question there.
The unit that's in question had no water damage, nothing.
Got it.
And there's units that were on existing concrete pads that suffered no damage whatsoever.
All right, so we'll know something by next week, or possibly earlier from your attorney if the appellate court agrees to actually hear your case officially. But please keep us posted, and otherwise, we'll talk to you after your court appearance in
I
Supreme
can't
Court.
wait to hear the
Herkimer
outcome
County.
of this when this is all said and done.
This has been a long-lasting deal, and I'm glad I was able to ask the question. Why don't you just give up? I mean, enough
you're
is
either
enough.
nuts or you're victims. I don't know which right now, but
Well, we can't give up our
Like I said,
income.
it's your
That's-
livelihood.
you know.
You know?
I understand what you're saying. I totally understand what you're saying.
It's
And the
again,
people there want to be there.
that's
We have
a
beautiful
big
tenants,
thing.
Have any of the tenants moved out?
A couple had, but more have moved in. I mean, there's a waiting list for this park.
the
That's
lady
how
that-
much it is.
No, the unit that's in question there is Dorothy Murphy's unit, is 114 in the back corner there. And that's the unit that they said that we put into the floodway. She couldn't wait to get back in. She was there a couple, 3 years prior too. And if these people are in question, if these people are nervous, and this is what we had said to the TV, the other day, why do these people want to be there?
Yeah.
Why? If I would be afraid if this is in danger. They're not scared.
All right. Go ahead.
No, I just wanted to ask if any of your tenants have been allowed to testify on your behalf at any of these hearings.
First of all, they've never been hearings. We have never been able to say a word in court.
Yeah.
Never.
Okay.
Never. So our tenants have been there in court.
And you won't at the appellate court either.
No.
Your attorney will handle all of that.
So we've never been able to say anything.
Yeah.
And they haven't either. They would be there.
All right, guys. We wish you the best, and let's see what comes of all of this.
Okay, well, thanks a lot.
Thank you so much,
Okay.
Bill and Virginia Jaquish, Creekside Mobile Home Park. And again, we have reached out to the town of Sherman Flats, and in fairness, they say they are not allowed to speak while this is currently in litigation. And that latest motion is what we're able to take their quotes from, which will come into play. It looks like that'll be August 3rd next week.